Welcome everybody to the next installment of the risk management video series. My name is Matt Johnson. I am counsel to the Realtors. Today I have a special guest, Joyce Hillis from my office, who does probate and estate planning work for my office, to answer a few questions on that topic, as it has been a topic of interest to our members. Joyce?
Thank you, Matt. Happy to be here today.
So first question, if there's an estate property involved, who is the client?
Who is the client? Well, it depends on how we got there. So in most cases, someone has passed away and they have a will, and someone will have to go to the probate court to get the will accepted, and someone's appointed as executor. So the first answer would be the executor. This is also prefaced on the fact that it would be a probate asset. There's a whole other world out there of trust assets. In that instance, it would be the trustee who's in charge. But either way, a realtor should make sure they see that piece of paper, either the certificate of appointment for the executor or the acceptance of trustee if it's a trust asset.
And process-wise, what should realtors be looking at for timing once they've listed a property with either the executor or administrator?
Once you know that the person is actually the right person, executor, administrator, trustee, then the timeline should be pretty normal moving forward. The only caveat is that you need to remember the person selling the property doesn't always know everything about the property. So there may be some bumps in the road with some disclosures and such that they just don't know enough information. So that might take a little longer to make the buyers happy about the agreement than if it was a traditional seller.
Great. And what about the deed that gets prepared if it's an estate property? Is there any difference?
Yes, and that's actually a very good question. When you enter the listing agreement or you put your disclosures, I always find it important to be upfront about the fact that the seller is an estate or a trust. In doing so, the reasons you can only give a fiduciary deed. No quick claim, no warranty. It's just the fiduciary, the executor, giving what they know about the property to the buyer.
Okay, great. And last question. Sometimes realtors get approached to sell property where there's an estate open, but it's not in New Hampshire, it's somewhere else, but the person who died had property in New Hampshire. What happens then?
So the state of New Hampshire requires that a separate probate administration be opened within the state of New Hampshire. So for example, we have everyone loves the lakes. You go up to the lakes, you're from Massachusetts, and you have your lake house. If the person was actually a resident of Massachusetts and only owned property up here, they'll need to open two probate estates, one in Massachusetts and a separate in New Hampshire. That you'll hear referred to as the ancillary administration. So you need that separate certificate of appointment from New Hampshire.
Great. Thank you so much for this information. It's been very helpful.